Дякую.
Thank you. Let's continue our meeting. Please invite into the room Naducheva Anna Petrivna. This is Natacheva Anna Petrivna, a candidate for the position of a judge of a Hague Anti-Corruption Court. Welcome. You are present at the special joint meeting of the High Qualification Commission of Judges of Ukraine and the Public Council of International Experts. You have the following rights: to submit motions, to provide oral and/or written explanations, upon consent of the chairman, to voice your opinions and objections with respect to the considered issues, and to give recusals. Do you have recusals as of now? No, I don't. Please repeat. No, I don't have recusals. Thank you. 5 minutes for the presentation of the PCIe member. Within 5 minutes, your response. And within 20 minutes, the session of questions and answers. This will be a separate session. Please, the presenter on your issue is a member of the PCIe, Mariana Lazarova-Traikovska. You're welcome.
President, the reason why this candidate is invited for this special joint meeting is because we have a reasonable doubt about the source of her assets. Namely, there is a reasonable doubt about the source of the candidate's assets given in her declared income, and also the income which is declared by her ex-husband, from whom she was divorced in May 2016. The candidate's assets include a car Hyundai Accent declared by her with the value of 170,000 Ukrainian hryvnias, car Toyota Camry declared by the candidate with the value of 2 million Ukrainian hryvnias, car Toyota Corolla declared by her to be 80,000 Ukrainian hryvnias, an apartment in the city of Mykolaiv with an area of 65.7 square meters declared by the candidate to be 27,871 hryvnia, a land plot with an area of 473 square meters declared by her to be 1,765 Ukrainian hryvnia, a land area of 1,400 square meters declared by the candidate to be 14,264 Ukrainian hryvnias, 2 unfinished houses, one of 60 square meters and another one of 300 square meters, and 1 unfinished apartment of 50 square meters. Also, there are savings which are declared by the applicant, and she is declaring 20,000 American dollars, 120,000 Ukrainian hryvnias, and 5,500 euros. Relying on the information from the file, there is a reasonable doubt as to whether the candidate made a true declaration to tax authorities. Namely, in accordance with the property declaration for 2017, the candidate received 42,031 Ukrainian hryvnias for her main job. That is approximately 3,200 Ukrainian hryvnias per month. As the candidate declares, she has 3 children and mother. Also, the candidate is renting an office for advocacy, but does not indicate the costs, despite the fact that she is the direct administrator of the information. Additionally, it was in 2017 that the candidate bought a car Hyundai Accent for 170,000 hryvnias. She is using this car, she is repairing this car, and she is maintaining on a daily basis this car. These circumstances give reason to assert that the level of expenses of the applicant does not correspond to its declared income. According to the information from the file, For the period from 1998 to 2018, so for 10 years, the candidate received income in the amount of 1,345,270 Ukrainian hryvnias. According to the data in the file, for the same period of 10 years, the candidate's ex-husband received income in the amount of 605,176 Ukrainian hryvnias. Also, the candidate was claiming that from her ex-husband there was a cash of $2,500 that was stolen, and by her ex-husband 930 euros were stolen, also gold and diamonds. This was reported to the police station. Her expenses include traveling to Georgia, Turkey, the Netherlands, Germany, Belarus, and other countries. At the same time, the candidate did not provide enough information about spending money on two unfinished houses, 60 square meters and 300 square meters, one unfinished apartment, 50 square meters, where the candidate's family invested. Additionally, it's complicated how the candidate spent a lot of her money and at the same time saved more than 32,000 American dollars. Mr. President, members of the Commission, in our view, there is a reasonable doubt as to whether the candidate declared her full income to the tax authorities, and this is the reason why we are raising reasonable doubts about the candidate's compliance with Article 8, Paragraph 4 of the Law of Ukraine on High Anti-Corruption Court. Thank you, Mr. President.
Thank you, dear colleague. Anna Petrovna, you have now an opportunity to provide explanations. You are welcome to do that. I provide my explanations. At once, I would like to note that until I've forgotten that my declared car, Toyota Camry, the price is not 2 million. There is some mistake. It is apparently it cannot cost 2 million hryvnias.
The price of the car is from the declaration which was fulfilled by the applicant on 21st January 2019 in 21:05 p.m. So it is written Toyota Camry, year of manufacture 2007, 2 million Ukrainian.
Це помилка просто.
This is just a mistake. Whose mistake? This is my mistake. Thank you. 10 was indicated mistakenly. Please continue. At once, I would like to explain with respect to family members who are supported by me. After divorce with my husband in 2016, I support two minor children. This is Anna, born in 2011, and Mikhailo, born in 2007. My mother she lived on the temporarily occupied territory in Lutuvne of Luhansk region until 2013. She has an apartment there that I also indicated in the declaration, but I don't know its price, and we have no documents for it. After 2013, my mother did not go back to the temporary occupied territory. I didn't let her go there. She lives at my place. Besides, she lives at her sister's place in Dnipropetrovsk, but as a person from the temporary occupied territory, she is registered at my place of residence. She has her own income. She has a pension of about 4,000 hryvnias. As of 2017, this is pension along with material assistance provided to persons who live here and who come from the temporary occupied territory. That is why I do not support her financially. With respect to my elder son, Yaroslav, in 2017, he was a student of the first course of Lviv Polytechnic University. He studied at free of charge. We didn't pay for his studies. He entered on his own, and he was supported by his father, as after the divorce, he stopped communicating with me for a year. This is about the persons whom I supported financially in 2017. With respect to my income for 2017, I would like to explain. In 2017, I worked as an attorney, and I have right now the attorney's bureau. The income of my bureau, the income of the money that we received at the settlement account amount to 712,000 hryvnias, and I provided the certificate along with my explanations to the PCIe. This is the movement of funds for 2017. Why I paid to myself the minimum salary, and I will explain why. Because I had plans, and I implemented these plans. In particular, in 2017, at the end, I founded the Attorneys Association. Right now, I have two assistants working. They are also officially registered as my assistants in the Register of Attorneys. One of them, and I also pay for this. One of them passed the qualification exam. Right now, she is on internship. And right now, I had expenses on my Attorneys Association. This expense is related to the purchase of equipment, computers, printers, furniture. With respect to the lease of the office, I filled in the declaration for the first time, so maybe I shouldn't have indicated the right of rent, but since this is the Attorneys Association of mine, and actually in 2017 I worked there on my own, I introduced this right of lease, but I'm not the leaseholder as an individual, but the Attorneys Association, and respectively the Attorneys Association has expenses on this. In response to the question about the rent, I provided the copy of the agreement of the works certificates, and it really confirms that the Attorneys Association bears these expenses, and there we can see the amount of these expenses in these documents that I have provided as attachments. Besides, in 2017, I received from my Attorneys Association financial assistance in the amount of 30,000 hryvnias that I indicated in the declaration. In my explanations, I also said that I did not declare social assistance that I received after the birth of the third child in 2012. This happened. I had my daughter born, and respectively, then for the third child, there was a payment of 100,000 hryvnias, from which I guess 10% or 10,000 or 20,000 were paid immediately, and for 6 years we received the amount amounting to 1,364 hryvnias per month. Since for some reason, while completing the declaration, I looked at the income that are indicated in the tax reports, and the social assistance was not indicated there. Again, as of the date of the declaration completion, I no longer received this social assistance as the child reached the age of 6. And respectively, this is my mistake. I just forgot to indicate this social assistance. Since I had savings, I really didn't think that this was economically efficient to pay to myself a higher salary or to pay dividends to myself, because I had real expenses on the Attorneys Association, and which I invested into the development of my legal practice. Besides, I had trips, business trips. In the information note, it was indicated that several times I traveled abroad. And there emerges a question, where did I receive funds to do that? I explained that these were the funds, these were business trips. I provide certificates. This is improvement of my qualification in Wismar, in the European Court. There was also a learning visit to Georgia. And for all that was done at the expense of funds of the Attorneys Association. And again, with a view to improving my skills and to improving my level, professional level, so that in the future I could, among others, earn more. Now, with respect to property. Again, I explained that neither me nor my family members, nor my relatives have never worked as judges, prosecutors in other state bodies, and that's why the declaration I was completing it for the first time, and I didn't have any friends to recommend with. That's why I tried to indicate everything I have and all the rights that I consider that I have. With respect to 3 cars, which I spent on, I do not spend money on 3 cars. 2 cars manufactured in 2003, and Toyota Camry and Toyota Corolla. They were purchased during the period of marriage with my ex-husband, and that's why they are joint shared property, and they were registered in his name. That's why I indicated them into the declaration. But after dissolution of marriage, actually, my husband had them and used them. And as a result of which, I had to buy for myself a car, Hyundai Accent, as I needed it during my legal practice, and besides I have children, school, and all the other things, and I don't have time to do that without a car. Respectively, car, Hyundai Accent that I purchased in 2017 with my savings. Expenses on this car maintenance are also borne at the expense of the Attorneys Association, since this is allowed by the legislation, and I use it in my legal practice. I do not have many expenses on it, as the car is running on gas with a view to saving money, and I didn't have to repair it till now. With respect to other property, the apartment that was purchased by us in 2001, yes, really, it was purchased for the price indicated in the agreement, about 27,000 hryvnias. This was at the time about $5,000, and it was the highest price in Mykolaiv, probably, honestly, for the apartments of such type. I do not know the price of apartments in Kyiv, but in Mykolaiv, a 3-room apartment with the area of 65 square meters cost about $3,500. This was the maximum price for such apartments. I have lived in this apartment since 2001, and I still live there with my children. I do not have any other residence. With respect to the land plots, I provided explanations, I provided sale and purchase agreements, and I attached them to my explanations, state certificates. The land plot that was purchased by our family in 2005, this is the land plot in Garden cooperation with the garden house that indicated as unfinished house with an area of 60 square meters. Because actually I have no documents for it, and in line with the explanations of the NACP, I introduced it as an unfinished house. As of the time of purchasing the land plot, it had this garden house on it, but it had no water, no gas. Subsequently, we equipped it with water, we connected water, and its area increased somewhat. But since garden houses, as of the time it was purchased, there was no opportunity to transfer them into use, so documents are not present for it. And the land plot that I declared with this garden house, it actually is not registered in my name. I provided just the sale and purchase agreement dated 2005. However, at that time, when it was necessary to re-register and register certificates, state certificates for the land, it was a period when state certificates were not actually provided blank forms for that, and that's why I couldn't re-register it. Then we had changes in the legislation, and they emerged the problem when state certificates were cancelled at all, and I had a situation when I didn't register in my name because I had no state certificate and had no documents to re-register. There was such a legal collusion, and right now, till nowadays, this garden house and this land plot are actually not registered, but I've indicated them into the declaration. The current value, I cannot say what's the current value. I don't think that is high. Maybe in the equivalent, it's about $5,000. This is about my property purchased and its respective expenses. With respect to the land plot that was purchased in 2011, yes, really, we purchased the land plot in 2011 for construction of the house, since the family was growing, and in the apartment with the area of 60 square meters, it was not enough for us. That's why in 2011 we purchased this land plot. In 2012, we decided. We built a fence, so we had the foundation laid, and we started constructing the house. But given the circumstances that happened in 2013, in 2014, it became clear that the savings we had were not enough for this house. I sent images of the house. This is not a house. It is actually just a heap of construction materials. So why I declared it as an unfinished house with an area of 300 square meters? Because it should have been like that based on the project. We submitted the declaration that it would be a residential house. Actually, there is constructed only the first ground floor, and since the end of 2013, it has remained in this state. There are no windows, no doors. This is just right now construction materials, and the level of readiness, the maximum is about 20%. We tried to sell it, but we couldn't do that because actually at that time when we thought to construct it, and the construction price was completely different, and maintenance expenses were different. Since 2014, gas price increased, and actually this house with area of 300 square meters is not in demand in Mykolaiv, and it will never be finished, I think. This is all the property I have. With respect to my income, in response to the questions provided by the PSU with respect to my income, I explained that the NABU's approach to take income for 20 years and to calculate this is 1,345,000 hryvnias, and to calculate them at the currency exchange rate as of 2011, it is not correct, because the majority of my income was received when the currency exchange rate was somewhat different. In particular, I provide calculations. I provided a table with dollar exchange rates where you can see that, particularly in 2006, my income amounted to 50,356 hryvnias, which amount to $9,971. In 2007, under the currency exchange rate, it was $17,188. In 2008, it was $26,136 respectively. This is just my total income calculated in US dollars, and amounts to $145,000, even more than that. Given the property that I have and savings that I have, I think that my income are objectively explain my savings and the property I have. However, I would like to know that I lived in a family. I had a husband who supported the family financially. At least I didn't have any questions about his income. Again, based on the information that was provided to me in questions, There we had information that the income of my husband for 10 years as of 2008 amounted to 605,000 hryvnias, something like that, and this was calculated again as of 2018. But I'm sorry, but in 2008 this was a completely different amount. This is almost 120,000 US dollars and not 20,000 like it was indicated in the information now. That's why I think that those savings and those incomes that I have right now are absolutely correct and correspond to the declared income. What else? With respect to the apartment, unfinished apartment, yes, I had savings that actually, these are savings that we intended to invest into the house, but we didn't invest them because evidently there was no family and there were not enough funds to finish the construction of the house. And that's why I decided to invest these funds into the apartment in Odessa. This is one-room apartment. Why I did that? This are the savings that I declared, and currently they've been invested. The building has been transferred into use in 2019, but I haven't registered the right of ownership yet. These are all my savings that will be in this apartment. The apartment is in Odessa. This is not far from Mykolaiv, where I currently live, so that my children would spend their holidays there. And I think this is an adequate investment of the capital, as if we can take into consideration the apartment in Mykolaiv and in Odessa, it is evident that even if nobody lives there, but just leases it, the income will be obviously completely different. That's why I calculated that, and I thought that I should have done that because I have many children and I have to provide for them. For now, I'm doing this like that. And that's, I guess, all. Yes, please, questions. Lutsuk, I have several questions to you. Please tell me. What was the cause of your name change? I would say it like that. My husband and I lived for many years. We lived for many happy years. 1 year was happy and the rest of the years were alone. That's why after the divorce I decided to change my surname. This is my maiden. No, I'm talking about your name. Name? Honestly, my parents named me Anna. And I was Anna, and only in passport they wrote Hanna, and they didn't ask me about that. And when actually I was passing this procedure of changing the surname, I decided to immediately change the name. Thank you, the answer has been received. I just wanted to clarify whether it was not related maybe to some other issues related to your activities. I have other questions as well. Please tell me. In your application, you wrote that you were asked to name several cases that are related to, that have some relation to corruption. You almost named nothing. You named a lot of civil cases, commercial cases. Didn't you have such cases? I have right now the case that is included in my dossier. This is about the head of the village council. No, I'm talking about your application. I think that this is the question of attorney's secret, and I don't think that my clients would be happy if I indicated their cases in my dossier. And I don't think this is suitable that they would like to be mentioned in my dossier as a candidate for the position. Please tell me, are you a member of attorneys' self-government bodies? Yes, I was elected in 2016. Thank you. I have no other questions. Do you have any other questions? Yes, Shotkas, please. Thank you. Please, Anna Petrovna, tell us, Do you know such a surname as Kривченко Володимир Петрович? Yes, this is my cousin. May I ask you, what is the power of attorney that you issued in his name in May of 2016 for the receipt of money as a gift? What are we talking about in this case? My mother has been saving money for a long time, honestly. She thought that at the old age she would live on a garden house that we purchased together with my husband, as evidently she would not return to the occupied territory. I would never allow her to do that. That's why she was collecting money and saving money to install heating in this garden house so that there would be a possibility to live there in winter. And since this is our joint property, and we had problems with my husband, I suggested to her, if you want to give this money for insulating the house and if you have an intention to live there, so let's do that. Let's document this gift officially. But as I've explained, she lives in not all time at my place. She lives at my place and at her sister's place in Dnipro. So my cousin also lived in Dnipropetrovsk, and currently he is in Brovary. She comes to him as well. At that time, he lived there. She lived at my brother's place, and that's why we registered it like that. I issued a power of attorney to him so that I wouldn't have to come here, so that he would receive money from her as a gift, so that we would have a documentary support if any questions relating to property would emerge. Is my answer clear, Anna Petrovna? And is it clear to you because you're looking at me and asking me whether it is clear? Is it clear for you? Yes, it is clear for me. The garden house is subject to division because it is joint property. And my mother wanted to increase its value. Money as a gift, power of attorney. To receive money as a gift. Yes. What is the relation to the garden house? What money did your cousin had to receive as a gift in order to transfer them to you? And why such a complex scheme? I'm sorry, or model? I've explained. I don't have any other explanation. Since actually Thank you. I've heard your answer. Thank you. You will repeat the same story for the second time. So, please, another question. In 2017, national police bodies recorded 3 notifications from you, at least what we can see, based on the data that we've received in February, May, and in July, about that there is a conflict situation with participation of you and your husband. In February, he threatened you physically in the office, which is why a unit of national police was called in May. Allegedly, there was a theft of gold and diamonds, and then you said that your son moved them somewhere and you found them, if I remember it correctly. But there was a statement, and you suspected your husband. And in July of 2017, at the place of your residence, your husband, without your consent, was taken out, things threatened, and respectively the police was called again. What decisions have been taken under these 3 cases? No decisions have been taken under these 3 cases. There were violations, and under one of the cases, criminal proceedings were initiated, but right now it is closed. It is about the theft of things, right? Yes. Okay, and in case when your husband threatened you physically, there was some procedure document filed, maybe a report. Was anybody brought to responsibility or no? You said that no decisions, no legal decisions have been taken, and I have a question. Why haven't you insisted on legal decisions? This is a difficult question. You see, this is the father of my children. I thought that the man... Anna Petrovna, I'm sorry, I will finish my question. Maybe it will be clear why I'm asking this, because firstly, you are an attorney. Secondly, today you are running for the position of a judge of the High Anti-Corruption Court. And for me, I would like to know how consistent you are in your actions. If you file about unlawful actions that happened with respect to you from the side of your husband, why aren't you consistent in so that some legal decisions would be taken? Maybe if in the first case you were consistent and responsible in your statement while calling police. This is not a joke. Maybe there wouldn't have been the second case and the third case. Why aren't you? Why haven't you insisted on adoption of some decisions under your statements? Because after the divorce, my son was not talking to me for a year. That's why I decided not to pursue this situation. And currently, I think that I've taken a correct decision, because actually, right now we don't communicate, and the degree of, so to say, hatred, not hatred, but this relations has decreased, and that's why there is no need in that. I realized that it would happen like that, but it was necessary to wait for some time. The answer has been provided. Please, the next question. Does anybody have any other questions? Yes, Vasilenko Andrei. I would like to clarify, because it seems to me that I've understood about the deed of gift. Did you receive these funds under this agreement? No, we are talking about power of attorney. I realize that. Power of attorney for the deed of gift, right? The power of attorney to receive money as a gift. To receive money as a gift, this is the deed of gift, basically, as far as I understand. Yes. Okay. Under this power of attorney, did he transfer money to you? Yes, he did. And what then? And nothing then. Because then this garden house was actually... My husband my ex-husband uses it, and I have even no keys to this house. So we forgot about this situation. Thank you. Thank you. Lazareva Traikovska, yes, please.
Mr. President, just two brief questions, Mrs. Petrovna. You've mentioned that your income as attorney for 2007, in your pleading, you've mentioned that your income as attorney in 2017 was 712,000 hryvnia. Is that
Адвокатського
so?
бюро. Так.
This is your...
Of the Attorneys Association. It was income of Attorneys Association.
What was your income as Attorneys Association, your personal income for 2017? Could you please repeat?
My personal income from attorney's legal practice, not of my Attorneys Association. Do I understand you correctly?
How much you made in 2017 as attorney?
I declared this amount, I think it was 41,000 as salary and 30,000 as financial assistance.
A number of 712,000 Ukrainian hryvnias during your pleading.
Так, але це дохід.
Yes, but there was income of my attorneys association. This is a legal entity, and expenses of the attorneys association are expenses that were directly borne from the account. And in line with the legislation, I could do that to cover my expenses and my legal practice. As I have explained, this was purchase of equipment since at the end of 2017. Actually, my activities broadened, expanded. This was the purchase of furniture. This was rent of property. These were expenses on the use of car. These were taxes again. These were trips, among others, abroad. And this also included expenses on business trips. Per diems that are not, under the law not subject to taxation, but even though they are actually my income.
For 2017, your income was 42,031 Ukrainian hryvnias.
Я пояснила, що
I've explained that besides I had return material assistance in the amount of 30,000. Besides, I did not declare social assistance for the child in the amount of 1,364 hryvnias per month. I've explained the causes. I just this is my mistake.
Дякую.
Thank you. Do we have any other questions? No questions? Okay, thank you, Anna Petrovna. Thank you for your sincere answers. Later we will take a decision. Thank you, goodbye. I ask to invite into the room Singaevsky Alexander Pilipovich.
This is Singaevsky Alexander Pilipovich, the candidate for the position to the High Anti-Corruption Court. We are welcoming you here. You are present at the special joint meeting of the HQCJ of Ukraine and the PCIe. You have the following rights: to submit motions, to provide written or oral explanations, upon consent of the chairperson to provide your opinions, objections on the considered matters, to give recusals. Do you have recusals? I do not have any recusals. There will be 5 minutes for presentation of the PCIe member. Within 5 minutes, you will have to give your explanations, and 20 minutes for question and answers sessions. Sir Anthony Hopper, you have a floor.
This candidate resigned as a judge of the...
Please switch on the mic.
Thank you. This candidate resigned as a judge in May 2016 from the Podilsky District Court. He says that he is now unemployed and has no income. When asked about this, he said that in 2017 to 2018, he borrowed 1,200,000 hryvnia, about 43,000 US dollars, and he borrowed this money from his brother, who lives in Khanty-Mansisk, Russia, which, as I understand it, is located in western Siberia. The candidate was first asked how he was financing his living expenses, given that he had retired. And his first replies were, all this time, having no income during the last 2 years, 2017 to 2018, I took a loan from my brother in the total amount of 1,200,000 hryvnia, based on the calculation of 50,000 hryvnia per month. I took a loan from my brother on a monthly basis in cash in the amount of 50,000 hryvnia, and we did not conclude any documents on this matter since there existed only oral agreement. Besides, I would like to state that being aware of my financial state and absence of a payable job, and the fact that my wife is on maternal leave, my brother, having such an opportunity, suggested to gift me these funds without further return. However, I agreed to his offer partially, and we agreed that I would receive the indicated money in a termless and interest-free loan and would be returning them as soon as I can. My wife did not know about this for some time because I didn't tell her about it because I was ashamed. He was also asked this question. According to the property declaration for 2017, you received a loan from your brother in the amount of 600,000 hryvnia. That's half because it's 1 year only. That is approximately $21,000. Your brother worked in the investigative division of the investigative committee of the Russian Federation in Khanty-Mansiysk. Please explain the following circumstances with respect to the matter. This is the question. Indicate the source of the funds. How did you take the loan, in cash or via a bank? Where did you keep the loan? And provide supporting documents. And he answered, currently my brother is financially assured and an independent person. In particular, since 2007 to the beginning of 2017, he occupied the position of the head of the investigative division of the investigative committee of the Russian Federation in the area that I've already mentioned. Income of my brother and his wife in this period amounted, that's 2011 to 2015, amounted to 30 million rubles, but in dollars, some $770,000. I'm continuing his answers. The loan from my brother was received by me on a monthly basis in the amount of 50,000 hryvnias from his personal savings, and that amounted to 600,000 hryvnias a year. These funds were spent as needed and were kept by me at home. He was asked about visiting Russia, and he was told that information we had showed that he had been on the territory of the Russian Federation 26 times between 2014 to 2016. And he said, yes, he had traveled often to the territory of the Russian Federation in his free time and after his resignation and retirement in 2017. Sorry, after retirement. In 2017, the brother started coming to Ukraine and stays here quite often. Since that time, I also continue visiting him, but it happened more rarely. He was asked, how was the cash transported? Who brought the funds? This was on a second set of questions. How often did this person come? What was the currency? And did the person declare the funds at the border? He replied, I repeatedly traveled to my brother in Russia, after that sometimes about 5 times. So he appears to be saying that after the start of the loan, he traveled to Russia about 5 times. Our information is that he did not travel to Russia either in 2017 or 2018, and that his last visit to Russia appears to have been in December 2016. He said, I repeatedly traveled to my brother to Russia, after that sometimes, about 5 times. Upon his request, I brought his funds to Kiev, where they were stored in the apartment purchased by my brother and his wife. Besides, after my brother's retirement in 2017, he has often come to Ukraine, and some funds, I do not know accurately what amounts and how often, have been brought by him. He goes on with his answer. I delivered cash funds by plane in the Russian national currency, ruble, as well as in US dollars. The amount of transported funds did not exceed the equivalent of 10,000 US dollars, which is why these funds were not declared. Knowing about the place where my brother's funds were stored, I'm continuing his answers, and having access to it upon preliminary consent of my brother on a monthly basis, I exchanged a respective part of the funds he owned, rubles or US dollars, for 50,000 hryvnia, which I took as a loan. We do not have any documents dealing with that alleged currency transaction. And sometimes he goes on to say, when my brother was in Kiev, he personally gave me such a loan in hryvnia. There clearly is a considerable amount of confusion as to how, when this money came to this country. But in addition to that, the Commission will want to consider whether someone who in 2017 to 2018 borrowed some 1,200,000 from his brother, whether he is a suitable person to become a candidate of the anti-corruption court. The second part of the case relates to a series of decisions he gave on the 31st of January of 2014. These decisions related, as I understand it, to drivers during the period covered by Maidan who had not stopped when required to do by a police officer. And there are 8 cases like that, all heard on that day. In all cases, the candidate found the persons guilty of committing these administrative offences and punished the persons concerned by forfeiting or suspending their driving licence for a term of 3 months. He was asked to explain the reasons for taking these decisions, and I think, and I will complete with this, it's fair to give his answer. I hope that it will be given to you in Ukrainian, but I shall read it in English. He says, I occupied the position of a judge of the Podol District Court of Kiev, and having a huge workload, considered a great amount of cases of different categories, including cases on administrative offences. Whilst considering the indicated cases, I took decisions regarding each of those based on the presence or absence of offences. At the same time, being an apolitical and independent person by all means, whilst considering cases, I was governed by the existing evidence and the law, as well as my internal conviction. According to the results of such cases, I took decisions on driving licence suspension and on fine application, considering each case separately. Further on, following the adopted law by the Rada of Ukraine, these persons were released from administrative responsibility. Besides, after the Revolution of Dignity, I realized that these cases could allegedly be related to the movement Auto Maidan, which I became aware of later, who were expressing their civil society position to the acting authorities. And I emphasize the words I'm about to read. His answer, considering these circumstances, I realized that I made a mistake having taken the aforementioned decisions. Further on, the majority of citizens in Ukraine started demanding the purification of authorities, including judges. Feeling my responsibility before the population, these circumstances became one of the reasons for my resignation, and I will remind you that he resigned in May 2016. And then he finishes by saying this, currently having become aware of the creation of the High Anti-Corruption Court in the few years after my resignation, I decided to try myself on the general grounds and new conditions of the competition for the position of a judge. Hence, I have indicated before another major problem of our state is corruption, and having experience and knowledge in the field of criminal law, I am willing and able to help Ukraine in getting rid of this disease. We, as we have done before, invite consideration of those decisions and the reasons he gave. I'm sorry that was a little long, but thank you, Mr. Chairman.
Thank you. Alexander Pilipovich, right now you have an opportunity to reply. If briefly, I can add that yes, With respect to the first issue, yes. For the last 2 years, I receive a loan from my brother on a monthly basis in the amount of 50,000 hryvnias. It amounts to 600,000 hryvnias per year. I think that the legal origin of his funds and his financial capacity to give me this loan, as well as my trips to him and the fact that he often comes to Ukraine, I've proved this by answering previous questions of the Public Council of International Experts, including by means of providing supporting documents. I would like to indicate that I provided copies of income certificates of my brother from the fiscal service. Besides, I referred to official website of the investigative committee where my brother worked. There we have declaration information about his incomes. Besides, I sent copies of passports, pages from passports with stamps of my brother and my passport as well, where you can see that, yes, we really crossed the border. I was traveling to him and he was traveling to Ukraine, and these circumstances, I consider that I've proved these circumstances. With respect to cases on administrative offenses, yes. I consider these cases. I do not deny this. I would like just to indicate that, yes, really, I've realized that maybe I've made a mistake, and I think that my mistake is that while considering these cases, I didn't know that they may have some political relations and that they were politically motivated. Since I considered these cases from the perspective of the presence or absence of offense, I only was governed by the law, those evidence that were given in the case, and also my internal convictions. I would like to know that just like other citizens of Ukraine, I was so a fan of my country, and I wish all the best for my country. I have my own views relating to its development. That is why I feeling really moral responsibility, I decided to resign. However, I would like to know that this was one of the causes of my resignation. Besides, I would like to note that while considering these cases, the case materials had no information about the fact that persons who were brought to responsibility had any relation to protests, mass protests, and while questioning these persons, they did not indicate about this, and currently, at least, I don't have any information that these cases were related to public protests in our country. If briefly this is all, please, you're welcome to ask me questions. Thank you. Alexander Pilipovich, do you have any questions? Kozlov and Tree and Sir Anthony Hooper will be the first to ask questions. And then we will have Kozlov and then Lutsuk. Yes, Mr. Chairman, I would like to ask all of us, all members of the meeting, to remember about 20 minutes for the session of questions and answers. Please, you are welcome to ask your question.
You arranged this loan with your brother in 2017. Sorry, I'll repeat that. You arranged this loan with your brother in 2017.
Yes.
But you did not go to Russia in either 2017 or 2018. That's right, isn't it?
This is not right. As I've said, I provided copies of passport pages with stamps.
We have looked at the passports, and it's always possible that we've missed something. When did you go to Russia in 2017 and 2018?
This was not once, this was several times. At least once per 2 months.
I don't want to waste the time of the Commission, but
Я не пам'ятаю
perhaps
дати.
Але
I could just show him the passport and he could identify us for when he went. So you think, you said in your answers to us you went to Russia about 5 times during this period, is that right?
no. About 5 times, I said that I brought money upon my brother's request about 5 times.
On 5 occasions in 2017, you brought money from your brother into Ukraine, is that right?
No, partially. Partially in 2016 and partially in 2017.
You haven't got the loan in 2016. The loan starts in 2017, you've told us.
Yes, correct. But I brought this money upon his request for him to Kyiv.
This is the money that he brought into this country, which you then used to finance your loan. Is that what you're saying?
Yes, subsequently in 2017, at first since the beginning of 2017, I started using a part of these funds.
Then you also went to Russia to get more money, about 5 times. Is that right or wrong?
About 5 times, but purpose is to get money. I didn't pursue this particular goal. I came to him upon his request because until 2017 he could not come to Ukraine at all. He didn't have such an opportunity due to his position.
My final question relates to the administrative offences which you found persons guilty of on the 31st of January. Are you saying that you did not realize that any of these administrative offences related to what was happening during this period?
Case materials had no information about that, and the persons who were brought to responsibility did not state about that, and I really didn't know that these cases could be related to public protests. Currently, I don't have this information as well. No complaints with respect to me have been filed in this respect.
So these 8 cases were just ordinary, everyday cases you thought at the time?
Yes, of course. Thank you. Any other questions? Kozlov? Yes, please, into the mic. Please tell us, have I understood you correctly, that every month you received the amount of money from your brother? This is what was indicated in your explanation. Yes, in general, 50,000 hryvnias, I could take it in parts, or I could 50,000 hryvnias every month. Yes, every month. How many times have you received these funds? How many times? Yes, and sorry to say, in what installments? I understand your question. These funds, as I've said before to Sir Hooper, they were stored here in Kyiv. I brought them. 1 second, please. You said that your brother was giving them to you. Yes, upon request, his money was brought to Kiev by me starting from 2016. Why? In Kiev, he had his own funds stored. Can you please explain what was the purpose of this transaction, why the head of the investigative commission needed this? He wanted to have funds here in Kiev. Why? I don't know about his purposes. He didn't explain it to me. He was telling me, "You are going home, please take this money." Okay, and in one currency, in rubles and dollars. Can you please name amounts that you received from your brother and transported across the border? Of course, it happened 3 times. It was 500,000 rubles 3 times, and twice this was the amount of $9,600 and $9,900. $500,000 in what month of what year? This was starting from 2016 in autumn, I think. I cannot recollect exactly. I cannot recollect the dates, exact dates. Please tell us in the declaration, integrity declaration, while applying for this competition, you didn't put any mark neither for 2017 nor for in clause 17 or clause 18, and also about the clause about the conflict of interest. Why didn't you put the marks there? I've explained it in the declaration that the candidate in clauses 17, 18, as far as I understand from instructions, should not be completed by the candidate. You think that this concerns, among others, candidate who was a judge? I cannot make up anything. Yes, I think so. Thank you. Thank you. Do we have any other questions? Щотка. May I ask you to recollect how you completed this declaration while being the judge, these clauses? I was not completing it. Okay, you resigned before it was introduced under the law on the judiciary in the version of 2016, so you haven't completed it. Okay, thank you. Lytsuk Pavlo, I have several questions to you. Please tell us. Do you remember about the cases where you took decisions with respect to drivers who were driving vehicles? There were 8 cases. I understand your question. I have hundreds of cases about administrative offenses. Of course, I remember that I had such cases. And these particular 8 cases that we are talking about right now, can you recollect where administrative offenses were committed by those persons who were suspected or considered to be violating traffic rules and specific reports were filed by police workers? I understand you. Unfortunately, 5 years have passed and I cannot recollect this. Was it on the territory of Podil district? It was in Kyiv, but I do not remember this. I will not make it up. Please tell us if the effective code of Ukraine on administrative offenses envisions that the question about bringing the person to administrative responsibility may be considered at the location of committing the crime, at the place of the vehicle registration, or at the place of residence. What grounds did you use while considering this case? Because from the practice and the number of cases considered, it was evident that these vehicles were tried to be stopped outside of Kyiv. What grounds I used, I cannot recollect this as well, because recollect the circumstances. Do you remember who took decisions on closing those cases due to the adoption of the law on prevention of persecution? Did you take such decision? Yes, upon motion of the prosecutor. And then there is a question, why then you are saying that you didn't know that these persons had some relation to these procedures as the law was adopted and you used it? And I wanted to add that then I learned that maybe these cases could have been connected with persons for the movement of Automaidan or participants of public protests. Please tell us, when you were filing the statement on resignation from the position of a judge, at that period, were there initiated some disciplinary proceedings with respect to you? There were no procedures and there are no complaints with respect to me. Thank you. Who? Yes, Vasilenko, please. Yes, Vasilenko and then Lorna Harris. Very briefly, this money that you were bringing to Ukraine, where they were stored before you started spending them? The place of storage of funds, not at the bank for sure, but I cannot indicate the place of their storage. You brought them. Did you give them to somebody? Not at my place. And to whom were you giving them? To some third parties? No. And where were taking them? I cannot say about a place of storage for the whole country to hear during the broadcasting. I'm not asking you to state the address. I'm just asking you, did you keep this money or were you transferring them to some third persons? I didn't give them to third persons. They were stored in residential premises. Okay, to which you had access? Yes, of course. And do you know, did anybody else have access to these premises besides you? Besides me? Only my brother's wife, when she came to Kiev, she had such an opportunity. Okay, I see. Now, your brother, he's doing what? He's retired. Does he have some activities or he's just a pensioner? He plans to go into business and for that he makes respective steps right now. Business in Russia or in Ukraine? If you know. I know. In Ukraine. In Ukraine. Okay, I see. Then another question. You came to him to Khanty-Mansiysk? I'm sorry? Not, we met also in Moscow. He often went on business trips to Moscow from Khanty-Mansiysk. Do you remember flights to Khanty-Mansiysk? What is the price of the air tickets to this Khanty-Mansiysk? I think you were flying. Yes, of course, but all the flights were from Moscow, and right now this is from Minsk and then Moscow. But yes, okay, but what was the price of this air ticket from Kiev to Khanty-Mansiysk? About 10,000 of what? Hryvnias. 10,000 hryvnias? If we are talking about all the transits. One side? No, both there and back. The answer has been... And what company have you been using? Belavia, Utair. Utair. Okay, thank you. We will check this. And another last question with respect to those persons with respect to whom you took decisions. Did they commit the offense? That is, where are their evidences that they committed the offense? If they took such a decision, then I think yes. Okay, yes. And in your opinion, if a participant of peaceful public gatherings and protests, should this person be brought to responsibility or not? No, I'm asking you. I'm a participant of peaceful protests. Right now, for instance, we have some peaceful protests, and the administrative offense has been committed. Should this person be brought to responsibility or not? The law is the same for everybody. Thank you. No other questions? Lorna Harris, yes, please.
Thank you. You have said that your brother and his wife stored money in Ukraine. Is that correct?
Так.
Yes.
Why?
Я вже пояснив.
I've already explained this. Their purposes and goals are not known to me, but as far as I understand, for their own needs, so this is convenient. They come here.
You also said that when you delivered cash funds, you were very careful. Sorry, you kept the sums at under $10,000 so that you did not have to report them. Is that correct?
He provided me with respective funds, and yes, so that there would be no obligation to declare it.
Aware that if they had been in excess of $10,000, you would have had to declare it.
Of course, of course.
Why did
Ні, я вибачаюсь, не 10.
I'm sorry, not $10,000, but 10,000 euros in Ukraine. But I brought money not over the amount of $10,000.
According to your passport details, you traveled 12 times to Russia in 2016, and your brother traveled 7 times in 2017 in the other direction. Would it not have been easier to transfer the funds by bank transfer?
Maybe it would have been easier. But I can answer this question like follows. My brother asked me and I brought this money. Maybe he needed cash.
He needed cash. Your brother asked you to take this money. I thought he-
Кошти.
I brought money for him. And only then, when we agreed that I would receive the loan, I took a part of this money and exchanged it in the amount of 50,000 hryvnias and took this money for myself, this part.
in 2016 were to bring money at his request and were nothing to do with the loan. Is that correct?
In 2016, yes. This was not related in any way to the loan.
Did it occur to you that there might be an illegal purpose in such transfers? You were a judge.
I don't understand what was the illegal purpose.
Money laundering?
He earned this money at his workplace, and I provided respective certificates, and I referred to the specific information from the declaration. These were his own funds that he wanted to store in Ukraine.
Is now in the flat or wherever it is stored in Ukraine? How much in money of your brother's is stored here?
I don't calculate his money, and recently he has been coming often to Ukraine and on his own provides me with this loan. I don't want to make up the amount because I don't know how much is stored there right now.
Has he ever transferred money to you by way of bank transfer?
I don't remember that. Thank you. Do we have any other questions? Sir Anthony Hooper, yes, please.
The 12 times you traveled to Russia in 2016, did you bring back money on every occasion?
No, I brought money in 2016, money 3 times, and in 2017 I brought money twice.
I would just, Mr. Chairman, ask the candidate if he could just take the passport and mark the 2017 travel. We have the 2016. If he could do that and just hand it back to someone, I would be very grateful. It's very difficult to read when you're only dealing with a photocopy.
Допоможіть, будь ласка.
Please help with the transfer of funds. Please sit down. You will be given that right now.
He does it outside. I don't require him to do it here.
Я можу показати тут.
I can show it here right now. You can show it right now? Yes, of course. I see these stamps. I also provided explanations attached to these photocopies, where I explained that we have no direct connection by plane with Russia, and I was flying through Belarus from Minsk. And here we have these stamps when I was flying to Minsk, and then from Minsk I was flying to Moscow. Then, subsequently, I would like to additionally explain that between Russia and Belarus, there is the customs union, and there was no necessary to indicate stamps while traveling to Russia, but recently they started putting their stamps in airports as well while crossing the border. Щетка Stanislav, yes, please. Please tell us, according to your application, your brother is a pensioner. Before that, he worked as the head of the investigative committee, division of the investigative committee in Khanty-Mansiysk Autonomous District. For how long has he been a pensioner? Since 2017. Please tell us, what was the salary of your brother? About $10,000 per month. Besides you, has your brother helped anybody else, or with respect to whom he has expenses? He also helps father. And does the brother have family? Of course. And all this came from his salary that amounts to, according to your words, about $10,000. Yes. His own family, you, and your father. I would like to say, to make it clear and to emphasize that my brother and I had always had warm family relations, and this is normal. Okay, I see, but please tell us, do you have any income right now? No, I don't have income. You continue being supported by your brother, yes. Retired man, yes. And has your brother managed to save the amount that he can continue doing that during the last 2 years, and now he has his personal savings? And the last question, for how long are you going to be financially supported by your brother? I'm not going to be supported by my brother for a long time. If I pass the competition, of course, as I will be appointed as a judge, I will have my own income. If I know, then I will be an attorney and I will engage in a legal practice. Do you have the certificate for the right to engage in legal practice? Yes, over this period of time, since my resignation, I've received this certificate. When did it happen? I received the certificate in December of 2017. Thank you. That's all, colleagues.
If I could just have the photocopies back with the marks. I'm happy for him to do it outside. I don't mind where he does it, but I just want to know. Thank you.
Добре.
Okay. I announce a break for 10 minutes.
Да, і поверну.
What do you think?
Did you get the answers? Were my questions what you wanted?
Yes, absolutely. Will you bring that back to me when he's finished? Thank you.
It's just juices, precious. Just juices, what it's all about.
Dear colleagues, let's continue our meeting. During the break, I advised Sir Anthony Hooper, the chairman of the PCIe. Candidate Zhovnovatyuk Victoria Sergeyevna has provided documents that we asked her to provide, and right now she is waiting outside nearby, and Sir Anthony Hooper suggested to finish the interview with her by means of providing additional explanations. Maybe she would like to provide some additional explanations. Sir Anthony Hooper not only is an honorable man, but also a gentleman. He is the most gentleman of all of us. Victoria Sergeyevna, we continue our meeting. Mr. Chairman, you are welcome to say a few words if you want.
Now, you told me this morning that the owner of the information contacted you after you had made your first decision. Do you agree?
Maybe I said that, yes, really. Without seeing the case materials, I assumed that the spelling error maybe was corrected on the statement and the own initiative. And within the provided period of time, I managed to clarify this the issue.
The first page of a letter from the bank.
Yes, from the case materials.
And where is the second page?
In particular, this statement consists of all 4 pages. It indicates certain circumstances, and in my explanations, I indicate that due to the short period of time that you've given to me to provide explanations with respect to the question that emerged today, unfortunately, I couldn't clarify whether the pretrial investigation under these proceedings was over, and in order not to disclose the information about the pretrial investigation that are also indicated in this statement. And please pay attention to the fact that this statement on the first page has legal entities with respect to which we are talking, and they are also blacked out by me.
So what date is the letter from the bank?
23 січня.
January 23. Below, at the bottom, in the right corner, you see the reference number 5416, dated January 23 of 2016. To Yakmanova is a court employee, and there is also a signature.
Can't produce the second page of the letter because it remains confidential. Is that right?
Так.
Yes, the case materials has the statement, and all 4 pages of the statement are present, but unfortunately I cannot provide this information without consent of the pretrial investigation body, because this is a part of the criminal proceedings, and information from which are protected by the law.
Chairman, as I understand it, the High Qualification Commission has very large powers to obtain documents. And here we have a candidate saying she cannot produce what appears to be the important part of the letter because it's subject, not the first page, but the rest of the pages are subject to some pre-trial proceedings. I just make that as a statement so that we can consider the matter lately. Now, so the bank sends you a letter. Yes?
No, the bank didn't send me the letter. This is the statement in the case materials of trial investigation, trial proceedings. Please pay attention that it is January 23 of 2017. This is the statement at that time, within the time you provided me, to provide explanations with the issues that emerged today. And this statement arrived to the court office. Yes, this is a statement, the first page of the statement. The matter is that due to the fact that during this period of time, 2 hours, with considering the conditions that we have outside right now, I came to the court building, I found the case, I printed out the statement. In the car when I was brought back, I was taking photos by phone and sending photos. Not scanners, but photos, and maybe the quality is quite bad. I have a better quality, and if you want, I can provide it. And there you can see the date better on this copy.
So this, what I thought was a letter is in fact a statement. Is that right?
Yes, this is a statement that is present in the case materials of that court hearing, within which the ruling was adopted on the temporary access, and then this statement was attached to that proceedings, and the decision on correcting the spelling mistake was taken.
This statement made by the bank comes to you somewhere around the 23rd of January.
Yes.
In this statement, there is a request to you to change the order that you had originally made.
The matter is that the content of this statement, with it, the bank has received, they received the ruling dated December 26, if I'm not mistaken, of 2016 for execution, and they raised the issue that this account, the indicated account that is not changed neither in the primary ruling nor in the second ruling, if you allow me to quote.
My questions are much simpler than your answers. In this statement, you were being asked to change the order which you had originally made, yes or no?
No.
Did you change the order on the second occasion by making it a more limited order?
In order to provide the answer to your question, if you allow me, I would draw your attention to the motivation part of this ruling, primary ruling dated December 26 of 2016. When the
you about that ruling, please, I'm asking you about your second ruling. We have all agreed, and you agreed, that in your second ruling you changed the order. You narrowed the order.
I made it more detailed in part.
You
мотивувальній
narrowed it.
частині.
You narrowed the order, please. You made it less wide than it was before.
If we look at the ruling broadly, taken in December of 2016, then I agree with you that looks like narrowing. However, I would like to, please, if you may, if you allow me to respond within 30 seconds, I would like to do that. May I do that?
В тому,
The matter is that investigative judge cannot move beyond the motion that the court receives. Taking into consideration that the motion was submitted where information that was provided that pretrial investigation was conducted with respect to specific indicated legal entities that were indicated in this motion. I, as the investigative judge whose main duty is to oversee control of fulfillment of persons within the proceedings, I had to check that by such intervention I would not harm and violate rights of any other persons. That is why the detective within the court here said that they were interested about information with respect to these specific legal entities. However, and I draw your attention that all this was reflected in the motivation part of my ruling. However, in the resolution part, without amending in the ruling on the correction of the spelling mistake, I indicated, in contrary to the motivation part, this specific four legal entities. That is why was my deep conviction that, legally speaking, this is not moving outside the scope of the motion that was submitted to the court. The subject matter was considered by me upon the motion of the detective. Thank you.
Narrowed the order, and you did so after the bank had sent in a statement of which we have seen only the first page. Do you agree?
My answer was announced.
I suggest, without referring it back to the NABU detective or prosecutor who had obtained at the first hearing a wider order. Do you agree with that?
Do you?
засідання.
Do you mean the notification about the court hearing or the receipt of the ruling? What notification? About the date of the court hearing or about the receipt of the ruling? Because this question was not asked in the morning, but there are receipts about the receipt of the court ruling and about its referral to the NABU. With respect to that nobody was called to come to this court hearing. It was the subject matter of the appellate reconsideration, and I really agree, as I've indicated by the appeals court while reconsidering my decision, that it was necessary to call the prosecutor.
More time. You make an order with the detective in the room and the request of the prosecutor. Yes? In December.
Ні,
No, I took a decision based on the submitted motion by the detective of the NABU with his participation in the court hearing and as envisioned by the Criminal Procedure Code. Such motions.
Answer is yes.
Погоджені. Моя відповідь.
My answer is that I took the decision with participation of the detective. The effective Code of Ukraine envisions the opportunity at the pretrial proceedings that both separate detectives, upon agreement with the prosecutor, can turn to the investigative judge, or prosecutors can turn to the investigative judge. In such a case, parties to the proceedings are either a detective who participates in these proceedings or a prosecutor if he submits this motion. In this particular case, the prosecutor was not a participant of the court hearing. The detective was present at the court hearing, which I indicated in the descriptory part of the ruling dated December 26th of 2016. And with
Please ask the question again. It's so simple. You made a ruling in December There
Так.
was a detective present, and you made an order.
Так.
Yes.
That order was taken, we now know, to the bank.
Це рішення
This ruling was provided to the detective for ensuring its execution.
The ruling was taken to the bank. We don't need to go into everything who's had breakfast. It's taken to the bank.
суд не направляє.
The court does not refer it to the bank, and it provides it to the detective who came to court.
Give it to the detective takes it to the bank, and he says, this is the order of the court. That's what happens in every country in the world.
In Ukraine, it happens as follows. After hearing the detective who comes to court with specific motion agreed by the prosecutor, there is a consideration of this motion. During such consideration, a participant of the hearing may be either a detective or a prosecutor. Then, upon the results of such consideration...
Sorry, this is a point of order. This is such a simple question. You give it to the detective takes it to the bank.
Tak.
We know that happened, because that's
Tak.
why the bank wrote. So why can't we just say yes? We don't need the whole code of criminal procedure of Ukraine to say yes.
Вибачте, але
I'm sorry, but I've understood that you are asking about my actions.
детективна
Yes, the detective sent this ruling to the bank, obviously.
And when the bank then makes a statement on the 23rd of January,
так.
of which we have one page only, and in effect they're asking for the order to be narrowed, to be made thinner, to be made less wide, whatever language you want. Yes or no?
In fact, yes.
And then you did what the bank wanted.
The matter is that
Що просить
the party who comes to court, this is just the first ground for taking materials of the case and to study them.
Bank, you did what the bank wanted. Yes or no?
No.
Did you narrow the order? We've already accepted you narrowed the order. You narrowed the order because the bank asked you to.
If the question to me is set as to a lawyer, then I have to answer it with legal language. In the understanding of the Criminal Procedure Code, I'm convinced that in this particular case, I corrected the spelling mistake since the essence of the decision.
Clearly hopeless. I'm just giving up my questions. I think I've made the point.
Дякую.
Thank you. Two brief questions from Andrei Kozlov. Please tell us, in what of the listed in your rulings, either in the first ruling or in the second ruling, legal entities could have officials, those subjects who could be subjects of crimes envisioned by Para 2 of Article 364 of the Criminal Code of Ukraine? Do you understand my question? No, I don't. I'm sorry. Article 364 contains an instruction, a note, where a special subject is indicated. And I'm asking you, in your rulings, you have listed 4 legal entities. I'm sorry, 5 legal entities listed. Oshad Bank and 4 other legal entities. In which of these legal entities there could be working as officials, those people who could be brought to responsibility under Article 364? In Oshad Bank or in other 4 legal entities? I think in the remaining 4 legal entities. I think so. Okay, thank you. I have no other questions. Thank you. Is that all, colleagues? Stepan Hladi, please. Victoria Sergeyevna, we are clarifying the circumstances of factual circumstances relating to your taken decisions. Please tell us, those resolution part, That was in the first court decision. Could it result in violation of other economic entities that were serviced by Oshad Bank? It could. I'm answering. The matter is that that account that was are not changed in both first and second rulings. This is correspondent account, and access to it allowed disclosing information about an unlimited circle of persons, clients of this particular bank. And I'm trying to explain that while considering about the essence of the motion, the motivation part of my ruling dated December of 2016, we didn't move beyond the studying the circumstances with respect to these legal entities. And my mistake while taking the first ruling was that while indicating this in the motivation part, these details were not indicated in the resolution part, and this could have led to the violation of rights of an unlimited circle of persons, clients of this bank. And that is, I'm sorry for a second, this was indicated by Oshad Bank representative in the statement to the court. Yes, he drew attention to this fact. So actually this is to some extent a statement on clarifying your decision. And you corrected, you did as corrected is a spelling mistake, and given an instruction with respect to which legal entities the access was allowed, right? Yes. And please tell us, the decision, your decision, was appealed with respect to the correction of the spelling mistake? Yes. And the appeals court cancelled based on you committing procedural violations and improper notification of the court hearing participants. Yes, the prosecutor had two demands. As the presenter of the PIC has mentioned, that yes, possibly the appeals court asked to check whether the order was narrowed, and the second grounds submitted by the prosecutor was non-notification. The appeals court have studied the materials and came to the conclusion that only improper notification was the ground. And results of the reconsideration of this case, I do not know them. Is that all, colleagues?
I'm sorry, Mr. Chairman, I gave the result of the thing. It went back, and the judge gave the order in the original form, thus suggesting that the concerns raised by my dear colleague were not something that worried the judge who made the final order.
Дякую. Останнє питання в цій співбесіді.
The last question during this interview. Please tell us, while considering this case, these proceedings, did you realize that the investigation concerned actions of officials of the state bank, Oshad Bank? The matter is that right now, for me, it is difficult to say that I didn't study the materials, and this question emerged in the morning, based on which the spelling mistake was corrected. If I had more time, maybe I would provide more detailed answers to these questions. Thank you. I announce the interview as over. Thank you. Please invite into the room Січеславський Ігор Анатолійович.
This is Січеславський Igor Anatolyevich, the candidate for the position to the High Anti-Corruption Court. We welcome you here. You are present at this joint special meeting of the High Qualification Commission of Judges of Ukraine and the Public Council of International Experts. You have the following rights: to submit motions, to provide oral or written explanations, Upon consent of the chairperson to provide your objections and opinions on the concerned issues, do you have recusals? No, I don't. Thank you. We have 5 minutes for the presentation of the PCAE members, 5 minutes for your response, and within 20 minutes we have question and answers issue. The presenter on your question is Fleming Denke. Please, you have the floor.
Thank you very much, Mr. Chairman. The PCIe has decided to refer the question of candidates' compliance with the criteria set out in Article 8.4 of the law of Ukraine on the High Anti-Corruption Court. And the reason why is a question about income. In the candidate's asset declaration for 2017, the candidate indicated his income to an amount of 233,850,000 hryvnias. The candidate's income for the period of 2013 to 2017 is indicated to 564,657,000 hryvnias, nearly $23,000. At the same time, in his asset declaration for 2017, the candidate has reported $32,000, equivalent to 800,000 hryvnias, as the savings on his bank accounts. There seems to be no income stemming from his law firm since it was created in 2011. Then I'll deal with the question about the $32,000 US dollars on the bank account. According to the explanation from the candidate, the funds in the foreign currency in the declaration for 2017 are comprised of his savings, which he should have made during his employment since 1997 on a regular basis. He emphasized that he didn't occupy positions related to the execution of state duties, didn't occupy positions of state service. Hence, in particular, he further has explained that he didn't have to declare his income in line with the legislation. He has stressed that he is the founder, owner, and director of his LLC Law Bureau. In December 2016, as an individual, he received 785,600 hryvnias from his law company as a loan, which were credited to his card account. The amount is not declared since it is obtained on a repayable basis. The conclusion is that the candidate in 2013 to 14 obtained dividends in the amount of a little more than 200,000 hryvnias from his company. These dividends in 2013 to 14 and the loan in 2016 are the only amounts he has obtained from his law firm in the period from 2011 to 2013. For the period of 2011 to 2013, the candidate had not obtained any salary from his company where he works. Besides that, the amount of the loan is bigger than the total income received by the candidate for the period of 2013 to 2017. The explanation provided by the candidate raises reasonable doubts as to whether he was complying with the tax legislation and therefore there's a reasonable doubt about his integrity. Thank you.
Дякую, колега.
Thank you, dear colleague. Igor Anatolyevich, you have 5 minutes to respond.
Вімкніть мікрофон.
And please start from the beginning. With respect to the amount that I declared as funds at my deposit accounts, I would like to explain the following. As I've indicated from the legal bureau, with respect to the way how the legal bureau, as far as I understand, the PCIe has this question that from where the legal bureau received these funds. For this meeting, I brought decisions, court decisions, according to which I submitted lawsuits to one of my clients in 2012. This was lawsuit on collection of the debt under the agreement of legal assistance provision. In line with this agreement, the client had to pay to me funds for legal assistance, but he didn't pay it. As a result, I had to turn to court. And the court decision, this case lasted for more than 4 years, almost. And the final decision of the High Economic Court was taken on June 14 of 2016. With respect to this decision, in line with this decision, my lawsuit was satisfied, and the respondent had to pay 765,000. This is the approximate amount, 765,000 hryvnias. That is, again, repeating, this was on June 14 of 2016. I received this amount. I have the respective payment order. Here it is, that this amount was received at the account of the legal entity of Legal Bureau of Siecheslavsky. It was received on 14 September of 2016. After that, I filed the additional lawsuit. As for the period when the first instance court in 2015 took a decision with respect to the amount of the debt, its amount increased due to the fact that the amount of penalties and interest accrued for the respondent also increased. So respectively, additionally, there was collected from the respondent about approximately 98,000 hryvnias. That is, the total amount was about 850 or 60,000, 860,000 hryvnias under these lawsuits. All these court decisions about which I'm talking right now, I have original copies of them right now here. I can provide or can show them. I'm sorry, not to the court, but to the Commission and the PCIe. So, in line with this decision, I received these funds at accounts of the Legal Bureau. From these funds, taxes were paid. I also have a payment order that proves this fact. And, in fact, I fulfilled all in line with the legislation that I had to do in line with the legislation. The amount that I received in 2007, I had at my bank accounts in 2017, comprises of the amount, not only from this amount, but largely it comprises of this particular funds. Again, I would like to note, as I've indicated in my explanations, written explanations, I did not declare this amount as my personal income of an individual, as these funds were received on a repayable basis as under the agreement of repayal as financial assistance. In line with the legislation that is effective, taxation legislation, I did not receive personal income because this was received on a repayal basis. That is I would like to know that maybe I did not provide everything in my written explanations, but did not provide sufficient arguments where the legal bureau received these funds, but right now I've provided these explanations. I have all the supporting documents to which I'm referring, decisions of the first instance court, the appellate court, and higher economic court, as well as payment orders that confirm the fact of receiving money and paying taxes. Thank you. Do you have any questions?
I'll just ask you, is it correct that money, earnings, salary from this company, since it was created in 2011, you haven't got any salary from your company except dividend in 2013 to 14? Is that correct?
Так, ви правильно.
Yes, it is correct.
Is it also correct that your sources of amount are stemming from many other companies or clients, or what you can say? I don't know if it's clients, but I can see here that you have got 65,000 kroners from a company called BADM. You have got 14,734 from Kyiv City Employment Center. You have become its 23,550 kroners from International Center of Financial Economic Development, Ukraine, and you've got lots of other amounts from companies and others, also from a private entrepreneur, and you don't have any amounts from your own company, your own law firm company, except the loan you took in 2017, 800,000 kroners. Is that correct? You declare it as to the tax authorities as salary. You should pay tax of it then.
I understand your question. I would like to say the following. In my legal bureau, I was the only person. That is, I didn't have employed employees, hired employees. That's why I didn't think that it was necessary to pay salary to myself as a hired employee, as I was a founder and owner of the company, and I could legally receive money as dividends. All the money that came to accounts of the legal bureau, this way I accumulated them and then I paid dividends to myself. That is a legal scheme, and I see no problems in this respect. The tax legislation of Ukraine allows that. Let's say so. I specialized during all this period of my legal activities as a specialist on tax cases. That's why, of course, this way I legally received those funds. Earnings that I indicated in my declarations. That is, I declared all the incomes.
Why did you took a loan on this amount? Why did you took it? Why did you take it? What was the purpose of it? Didn't you trust your law firm in such a way that it could remain in the law firm? Why did you withdraw the money and put it in your own bank account? And could you use the money then?
I understand your question. I would like to say in response, this was the end of 2016. At that time, if you don't know that, we had the nationalization of Privatbank. That is a large bank, the largest bank in Ukraine in terms of its assets, where I, as a director of legal bureau, kept this money. I would like to say that at once I received these funds, I placed them at the deposit account of the legal bureau, that is limited liability company, legal entity. They were there for several months under this bureau. Due to the fact that there was good interests, the bank offered good interests, and I thought that it would be profitable. After that, after the process of nationalization of private bank started, and nobody knew how it would end, there was huge in Ukraine in panic in this respect. Most people who had some savings in private bank was trying to do something with them, and this way I also acted in this way. And I decided that I would not take a risk with such amounts, and I decided to withdraw this money from private bank, and this way I did that, as I did.
But look here, you have the money from your law firm in a bank account in a bank, and then you withdraw the money and put them into another bank account, but in your private name, in your own name. What is the purpose with that?
Я вже сказав, Дмитро.
I've said the purpose was to prevent my money from risks related to the fact that the bank could not fulfill its obligation, and I placed this money at another bank because my legal bureau Syczeslavsko had no other accounts in other banks at the time it was working, and right now it also has no bank accounts in other banks but private bank.
Is it forbidden for a company to change bank? To go with, to put the money from one bank to another bank? In my country, you can do that very often.
I also agree, but at that time I thought that it would be better to do that way at that time, and this way I made the most use of these funds, in my opinion, and their correct investment. I thought it would be better to do that like that.
Correct that when the money is in your account, you can use the money.
Of course, I can use this money, but I have not withdrawn and have not used actually this money. Thank you. Do we have any other questions? One question, Kozlov and Vasilenko. Vasilenko, no? Then Kozlov, please. Please tell us. Your mother received in 2013 two real estate objects. And then, actually, at both of these addresses, we have calls to the police. And who and why did that? Police calls? Maybe he was calling somebody. I don't know that, honestly. I don't know about such moments. Have you looked through the Nabu's note before this meeting? No. I was provided it with the letter before the meeting where I had one question, which was asked by Mr. The honorable member of the PCIe. Who gifted these objects to your mother? With respect to the apartments that my mother has, the first apartment was purchased by her in 2013. This is a two-room apartment where she currently lives. She bought it. No, I'm asking about gifted. This was her mother. Her mother, Kozachenko Vera Lazarevna, gifted it to her, and she lives there right now. And about 6 of tenths of the apartment. This way, my mother, so to say, received it from a person. I'm not well aware of this scheme. Maybe this way she tried to somehow optimize her. I don't know about this. I have no relation to this apartment. That's why I cannot explain about my mother. I have no relation to them. Thank you. In social networks, you indicate as your place of residence Kyiv, and at your website, we also have the postal address in Kyiv at Kopernika Street. Please tell us, why don't you then declare any real estate object in Kyiv? I have no property in Kyiv or in any other cities. I don't have any real estate property. Thank you. Andrei Vasilenko, yes, please. A very brief question. As of the date of receiving the loan from your legal bureau, your personal accounts, did you have these accounts at other banks? Of course, of course. So this was a situation that you had accounts not only in Privatbank, right? Yes, thank you. Thank you. I announce the interview over. Igor Anatольevich, thank you for your answers. Thank you. I would like just maybe, should I provide documents, what I mentioned, courts decisions, payment orders, so to prove that I was telling the truth. Mr. Chairman, may I ask your attitude to this?
It's too late.
It's too late. We cannot accept any additional documents. They were not requested. Okay, the decision will be taken later. Mr. Chairman, before we inviting the last candidate for today, I would like to say that I've just received a document that officially came from candidate Burbella, and I think here we have more than 100 pages. What should we do with it? Please into the mic. Use the mic, please. I would like to focus your attention, draw attention to the fact that this is the candidate who promised to provide images of his wife. And he provided them. But besides, he also provided additional documents.
If he produces a photograph of his wife, we'll take it. If he produces anything else, the answer must clearly be no.
Дякую.
Thank you. We cannot attach these documents. Please pass it to the presenter, but thank you. Thank you, and I invite into the meeting room Yurkevich Yuri Mikolaevich. This is Yurkevich Yuri Mikolaevich, a candidate for the position of Judge of a High Anti-Corruption Court. Welcome. You are present at a special joint meeting of the High Qualification Commission of Ukraine and the Public Council of International Experts. You have the following rights: to submit motions, to provide oral and written explanations, upon consent of the chairman to voice your opinions and objections with respect to the considered issues, and to give recusals. Do you have recusals? No, I don't have. 5 minutes for the presentation of the PCIe member. Within 5 minutes, your explanations, and within 20 minutes, questions and answers. The presenter on your issue is a member of the PCIe, Mr. Aurelius Gutauskas. You are welcome, colleague.
Thank you, Mr. President and dear colleagues. The reason why we are inviting this candidate to this joint meeting is there is unable doubt concerning the candidate's integrity with respect to his answer to question related to the origin of the funds for the acquisition for the property. According to the NABU's data from 1998 to 2018, total income of the candidates amounted to the 965,536 While what of this wife amounted to the 116,194 Ukrainian hryvnias. At the same time, according to the candidate's declaration for 2017, on 10th of November 2017, he purchased the apartment in Lviv for 964,544 Ukrainian hryvnias. It's approximately around 36,400 US dollars. Before that, on 24 of April 2013, the candidate and his ex-wife purchased the apartment in Lviv region with the total area of 18.4 square meters for 148,000 Ukrainian hryvnias. It's around 23,000 US dollars. Besides, the candidate has a car, Hyundai Accent, purchased in 2014 for 142,000 Ukrainian hryvnias, is around 12,000 US dollars. According to the candidate explanations, the sources for acquisition of the mentioned assets are his income and the gifts from the parents of the 6th of May of 2011 in the amount of the $60,000 of US dollars on the acquisition of wedding. To corroborate his explanation, he adduced parents of the written explanation. So the explanations provided by the candidate about the origin of the funds raise a reasonable doubt concerning his integrity. Additionally, according to Article 719 of the Civil Code of Ukraine, the agreement on the gift of currency values to an amount exceeding 50 non-taxable minimum incomes of citizens shall be in writing and subject to notarial certification. In 2011, it was around 2,300 Ukrainian hryvnias, or about 300 US dollars. Thank you.
Дякую. Юрій Миколаївич.
Дякую. Юрій Миколаївич, please your response. Thank you. Dear Chairman, dear honorable members of the PCIe and members of the High HQCJ. I am 33 years old. During my professional career, I dedicated it to academic work. At 23, I wrote the thesis, and then I had the PhD thesis. Main property that has been voiced by the honorable international expert has been actually acquired at the expense of financial support of my family, my close people, my relatives, my family. In particular, with respect to what has been said, yes, really, on May the 6th of 2011, my parents gifted me monetary funds in the amount of $60,000. This gift, they motivated it with the fact that I was marrying that year. On July 12th of 2011, I had a wedding, and respectively, at the same time, they warned me that they would not include me then in the future in their will because my older brother, Yurkevich Mykolaevich, would live with them. Yes, really, when the deed of gift was occurring, I informed my parents that based on the provisions of the Civil Code of Ukraine, the transaction on the deed of gift for the amount that exceeds 50 non-taxable minimum incomes of citizens shall be notarially certified. As I've informed my parents similarly that the consequences of such transaction, non-compliance with its form is the lack of its validity, but invalid transaction may also be executed, and to apply consequences of this transaction may be only upon the statement of interest parties. Respectively, my parents refused to notarially certify this agreement. They proceeded from the fact that their word was sufficient for that, since we had family relations. There were no grounds not to trust each other, and in turn, I was in the status of the person who received the gift. I was not the grantor. So in any way to convince them that it was necessary or to make them notarially certify the agreement, even based on the legal nature of the deed of gift, I didn't have such an opportunity. With respect to the second mentioned, at the expense of these funds, in 2017, we purchased, the apartment was purchased that has been mentioned. Respectively, proceeding from the savings and also the savings accumulated during my entire employment period, I also purchased car Hyundai Accent. Besides, I would like to draw attention to the fact that with respect to the purchase, together with my ex-wife, of the apartment in Lviv, its area is really only 18.4 square meters. It was purchased again partially with my savings, 68,000, and partially with my ex-wife's savings, 68,000 hryvnias. And the funds that were gifted to us on the occasion of our wedding celebration, 52,000 hryvnias. Subsequently, besides the way, this apartment, since we divorced and we stopped our marital relations, we gifted it to the benefit of our minor daughter, Anna Maria. At the same time, with respect to this property, as far as I understand, I'm talking about the property that has been voiced in the presentation. At the same time, I would also like to indicate that neither I nor my family have never worked at in state bodies or in the local self-government. My family has always been very convenient in the standard of life, and we've been governed by moral and honor provisions, and respectively I am being governed by such norms in my activities. If you have any other questions with respect to this or other property, I'm ready to answer them. Thank you. Please, questions. Vasilenko, then Kozlov. A very brief question. Your parents, what are they? What is their occupation? My parents currently are working in the hospital, and besides, they are doctors. That is my mother, the head chief doctor, and they are also retired. In order to confirm the real financial capacity to make such a gift, I've asked them to provide their income statements and certificates, as the certificates show only for the period since 2004 to 2011. Inclusive of their incomes, the amount exceeded $100,000. At the same time, their employment record, my mother worked as the head of the medical institution, and my father worked as a surgeon, and they also received the pension. Is it a private hospital? No, this is a communal enterprise, but we have to take into consideration the fact that the currency exchange rate of dollar varied since 2004 to 2014 from 4 hryvnias and to about 8 hryvnias per dollar. And respectively, they had an opportunity to save. And they also been saving their funds starting from 90. If you've calculated all this, what is the average salary? For instance, in what was the average salary of a doctor in 2004? I can provide right now the answer. So yes, please provide this answer. 1 second, please. I have a certificate and I've attached it. So if we are talking about 2004, for 2004, my mother had received the income of, under her workplace, 13,060 hryvnias, 90 kopecks. I've asked you about 2004, right? The currency exchange rate was what? About 4 hryvnias 92 kopecks. 5, approximately 5. 13,000 for a year, right? Yes. So it's 1,000 hryvnias per month, right? 13,000 divided by 12, but my father also had income. So 13,000 divided by 12. This is slightly over 1,000 hryvnias per month. 1,000 hryvnia divided by 5, that will be $200. And again, these salaries did not change that much, but even became smaller with the increase on the currency exchange rate. Your brother was working in the same hospital? Yes, he is in the same hospital as a surgeon, right? Not a head. Okay, so his salary is approximately the same, right? Yes, yes, approximately. So let me then provide a comment with respect to your question, if you allow me. My purpose when I turned to my parents to receive this certificate, I didn't pursue the goal to provide exact calculations of their salaries. It was to prove their financial capacity to save money. They've been saving their money starting from the very beginning of their employment career. At the same time, the salary of my mother as the head of the medical institution amounted... I'm sorry, right now we are talking about another question. If you will be asked about that, you will answer that. Kozlov, please. Please tell us how much did your parents manage to save during the period of their employment, as you name it? Again, I did not pursue the goal of exactly learning the exact amount of their savings. My goal, when I turned to my parents, I will stop you, please. When you are talking about financial capacity of your parents, may I hear some clear figure that what they could afford to buy or how to spend? What amount of money could they spend? What amount of money could they spend? I think about 40–50% of what they earned they were spending. 40–50% from their earnings. And you said what were their earnings during their employment? I was not talking about during their employment. I was talking about the period from 2004 to 2011. And what was the figure? And what was the figure? Over $100,000 of their income, right? Do I understand you correctly from this explanation that $60,000 were transferred to you? And how did they spend the rest? Do you know that? I don't know about that. They spend on their needs. So they also have current needs. They have my older brother who lives with them and who financially supports them. This is all the family budget. This is family. May I? Yes, Vasilenko, please. So, yes or no? If I understand you correctly, then for the period from 2004 to 2011, if we assume that they gifted $60,000 to you, so then both of them, for 9 years, were living on $40,000, right? If their total income was $100,000, $100,000 minus 60,000 equals to 40,000. Not right, because my goal when I turned to them was to show their financial capacity, and they started savings in the 90s. So, thank you. As far as I understand, your grandfather also gave you money, right? Yes, he funded the apartment. Sorry, it's quite a sad question. You indicated that he gave you money in 2009 and died in 2003. In 2013. Yes, clear. Okay. What was the source of income of your grandfather? What was his activity? My grandfather? worked for his life, starting from the age of 14. He worked at management positions. He was the head of the furniture plant. After Ukraine became independent, he was also at the management positions at the furniture plant. He was also engaged in entrepreneurial activities. So he produced and sold for goods. So he also was awarded with the individual pension, which was quite high. Do you have any documents to confirm this? I've only managed, unfortunately, to get the statement from his children that, yes, really, these funds were provided, but since he died in 2013 without him, during this period of time, it is practically impossible to get this information. Another question. You wrote that in order to provide the funds, he even had to go to court with Nadra Bank. What is the story about that? It was 2009. He had a deposit at Nadra Bank amounting to about 13,000 hryvnias, and he turned to the bank to get this money back. They were not giving this money back, and he turned with a claim, and then there was an order issued, and these funds were returned to him. And the last question, you said that a house that you received with an area of 112 square meters was actually constructed by your grandmother. This grandmother is the grandfather's wife, or no? This is a grandmother of my under my mother's side, and I inherited property from her. This is a village in Sambir district. You are saying that the area was from the very beginning 112 square meters. 112.4 square meters according to the technical passport. And the technical passport is from the Soviet times? Yes, it's dated 1989. The house was not repaired, was not reconstructed, and in fact in this village there are many empty houses. Thank you. Do we have any other questions? Yes, please, Lorna Harris.
In connection, please, with the donation at the time of your wedding in May 2011 of $60,000. Can you tell me how you received that gift? Was it in cash?
Yes, I can answer this question. Unfortunately, I can state that my parents and my family did not trust the national currency, and that's why they stored their savings in US dollars, and they didn't trust the banking system as well, so it was a gift in cash.
You have no banking documents to substantiate the fact that this gift was given to you by your parents?
This gift was not made by bank transfer, so this was cash. Vasilenko asked you, did your parents leave for $40,000 that remained after they gave you $60,000? But another aspect as well. In 2012, they purchased a new car, Volkswagen Polo, manufactured in the same year. So what funds did they use to leave, and what was the price of this car? I cannot say this right now because I have not asked about the price of this Volkswagen Polo, but I repeat again, they had savings till 1990s. They've been working throughout their entire lives, so they could afford this. They were not state officials. All their earnings consist of those earnings that they received as an official source of income. Again, I did not pursue the goal of how much they earned throughout their life. My goal was to prove that this had this financial capacity even during this short period from 2004 to 2011.
Candidate, I did not understand your explanation, and if you could give it to us again, respecting the discussion with your parents about the certificate that the law required to be completed. Can you repeat your answer? Did your parents complete the certificate, and was it filed?
Yes, of course. I can repeat them. I was telling about the fact that as of the time of gift, that is on 6th of May of 2011, as I've indicated, the transaction on the deed of gift in the amount that exceeds 50 non-taxable minimum incomes of citizens shall be notarially certified, and there are legal consequences of not complying with this form. And if the form of this transaction is not complied with, it can still be executed. So this transaction was fulfilled as of the moment they transferred to me this money. Our relations were based on trust, and respectively, I was not in the situation, since I was receiving the gift, I could not convince my parents to go to the notary and tell them to notarially certify this transaction. That's why this happened actually by means of giving me cash. They gave the written explanation while that they really gave me this cash.
You're a lawyer at the time, yes, and you explained the legal obligation to file the certificate. And your parents are doctors, so I'm assuming they're intelligent people. And you're saying to us that they did not file the certificate that the law required them to file on the gift. Is that correct?
Yes, they didn't provide consent to this notary certificate because our relations are based on trust with our parents, and respectively they told me that they were not going to notarially certify it, and they were not going to go to court on the return of these funds. Yeah.
Well, you may have a trust relationship with your parents, but do they have a trust relationship with the authorities?
Звичайно.
Of course. Of course.
File the certificate.
They thought that there was no need in that, as I'm their son. And their word was enough.
You provided them legal advice that son or no son, they have to file the certificate.
I provided this advice, but they didn't listen to me.
All right, thank you.
Mr. Zazechny, you do not quite understand what he is asking you about. He is hinting that relations with tax authorities. But as far as I remember, gifts between relatives of the first order are not subject to taxation.
Лена, Прилипка.
Прилипка, Луцюк, and then you. Please tell us, where do your parents live? My parents live in village Ralivka of Sambir district. You've looked through the Nabus note? No. They have a house with an area of 362 square meters. As far as I know, the house is half of the house is in ownership of my brother. In order to service this house, even half of this house, in your opinion, what is the amount of money needed per month? As far as I know, they currently spend no money to service this house, as they live with my brother, who is an entrepreneur, and he is responsible for these expenses. Lutsuk Pavlo Sergeyevich. Yuri Mikolavich, I have a question to you. You are a candidate for the position of a judge in the High Anti-Corruption Court. But throughout all your entire life and academic activities are related to civil legislation and civil process. In your opinion, won't you be there, I'm sorry for the words I will use, but half your parents are doctors, so this is medically related, so won't you be a strange object there? On the contrary, I think that the purpose of the effective application of the anti-corruption criminal legislation is not only punishment of the guilty person, but also ensuring interests of the affected parties and compensation of the harm inflicted upon the affected parties. And that is why I think that knowledge of the commercial law and the civil law are quite necessary for that. But none of your scientific works is related to the compensation of harm. Thank you. I have, for instance, if we are talking about my scholarly interests are also related, among others, to the effective commercial activities. And joint commercial activities, as of now, and in this particular spheres, is a very topical issue, especially with respect to the anti-corruption legislation. And the last question, Mirjana Lazarova-Trajkovska.
Mr. President, now, Mr. Yuri Mikolaevich, you are saying that you received in 2009 from your grandfather apartment in Lviv as a gift? Yes or no?
He funded the purchase of this apartment.
Your name?
He provided funds. The agreement was registered at once in my name.
The cost of this apartment is 444,913.50 hryvnias, Ukrainian hryvnias, and
yes,
then 50.
Approximately over $50,000. Yes.
And if the relatives of first line, mother and father, are not obliged to pay taxes for gifts, this is not covering the grandfather. Did he pay taxes for this apartment as a gift?
As far as I know, my grandfather, with respect to the funds he provided, paid all the taxes. The situation happened in a similar way like my parents and I had when my grandfather in 2006 warned me in 2006 when I graduated from the law faculty. I faced the question of choosing my professional activities, and since the fifth course I was working, and we had a conversation with my grandfather and my father that they wanted me to go to to pursue the PhD degree, since I was his first grandson who graduated with honors. And my grandfather told me that he would do everything possible to purchase the apartment in my name, and at the same time he wasn't including my father in his will.
How were money transferred to the company that was building this apartment? Through bank or?
As far as I remember, this apartment was mortgaged, and it was going through banking institution, but I'm not ready to state for sure right now what happened in 2009. Sellers of this apartment was mortgaged, and it had to go through bank.
Have agreement for gift or some kind of document that this was gift from your grandfather?
I have no deed of gift. It was again based on trust.
Thank you.
Thank you. Mr. Chairman, may I announce about the end of this interview?
Yes, Mr. Chair.
Thank you, Yuri Mikolaevich. Thank you. Goodbye. Later, a decision will be taken. Thank you for your answers. Let's move to the deliberations room.
Працюємо.
Are we on? Dear colleagues, let's continue our meeting. And I announce decisions. That the candidate for the position of a judge of the appeals chamber of the High Anti-Corruption Court, Burbela Yuri Sergeyevich, complies with the criteria set out in Article 8 of the Law of Ukraine on the High Anti-Corruption Court, has not received a sufficient number of votes determined by this article. To recognize the candidate for the position of a judge of the appeals chamber of the High Anti-Corruption Court, Burbela Yuri Sergeyevich, as such, who stopped participating in the competition announced by the Commission on the 2nd of August of 2018. The next decision that candidate for the position of a judge of the High Anti-Corruption Court, Holovate Roman Yaroslavovich, complies with the criteria set out by Article 8 of the Law of Ukraine on the High Anti-Corruption Court, has not received the sufficient number of votes established by this article. To recognize the candidate for the position of the High Anti-Corruption Court, Holovate Roman Yaroslavovich, as such, who stopped participating in the competition announced by the Commission on the 2nd of August of 2018. The next decision that candidate for the position of a judge of the High Anti-Corruption Court, Zhovnovatyuk Victoria Sergeyevna, complies with the criteria set out in Article 8 of the Law of Ukraine on the High Anti-Corruption Court, has not received the sufficient amount of votes determined by this article. To recognize candidate for the position of a judge of the High Anti-Corruption Court, Zhovnovatyuk Victoria Sergeyevna, as such, who stopped participating in the competition announced by the 2nd of August of 2018. The next decision that candidate for the position of a judge of the High Anti-Corruption Court, Zanini Diana Volodymyrovna, complies with the criteria determined by Article 8 of the Law of Ukraine on the High Anti-Corruption Court, has not received a sufficient number of votes set out by this article. To recognize candidate for the position of judge of the High Anti-Corruption Court, Zanini Diana Volodymyrovna, as such, who stopped participating in the competition announced by the Commission on the 2nd of August of 2018. The next decision that candidate for the position of a judge of the High Anti-Corruption Court, Ivasin Alexander Romanovich, complies with the criteria set out by Article 8 of the Law of Ukraine on the High Anti-Corruption Court, has not received the sufficient number of votes determined by this article. To recognize candidate for the position of a judge of the High Anti-Corruption Court, Ivasin Alexander Romanovich, as such, who stopped participating in the competition announced by the Commission on the 2nd of August of 2018. The next decision that candidate for the position of a judge of the High Anti-Corruption Court, Natocheva Anna Petrivna, complies with the criteria set out by Article 8 of the Law of Ukraine on the High Anti-Corruption Court, has not received the sufficient number of votes determined by this article. To recognize candidate for the position of judge of the High Anti-Corruption Court, Natocheva Anna Petrivna, as such, who stopped participating in the competition announced by the Commission on the 2nd of August of 2018.
The next decision is that decision of the candidate for the position of the judge of the High Anti-Corruption Court, Sinhaevsky Alexander Pilipovich, is compliant with the criteria set out in the Article 8 of the Law of Ukraine, to recognize as such who has not
to recognize the candidate Sinhaevsky Alexander Pilipovich as such, who stopped participating in the competition announced by the Commission on the 2nd of August of 2018. The next decision that candidate for the position of a judge of the High Anti-Corruption Court, Sichaslavsky Igor Anatolyevich, complies with the criteria set out by Article 8 of the Law of Ukraine on the High Anti-Corruption Court, has not received the sufficient number of votes determined by this article. To recognize the candidate for the position of a judge of the High Anti-Corruption Court, Sichaslavsky Igor Anatolyevich, as such, who stopped participating in the competition announced by the Commission on the 2nd of vote of 2018. The next decision that candidate for the position of a judge of the High Anti-Corruption Court, Yurkevich Yuri Mykolaievich, complies with the criteria set out by Article 8 of the Law of Ukraine on the High Anti-Corruption Court, has not received the sufficient number of votes determined by this article. To recognize the candidate for the position of a judge of the High Anti-Corruption Court, Yurkevich Yuri Mykolaievich, as such, who stopped participating in the competition announced by the Commission on the 2nd of August of 2018. The agenda is over. I announced the meeting over.
I just say that Judge Gutauskas will not be with us tomorrow, but he rejoins us on Monday. And secondly, are we starting at 9:30 tomorrow as usual?
Так.
Thank you.
Yes.